Yeah.
Afternoon, everybody. Firstly, to introduce myself, I'm Sanele Sibanda. I'm a teacher at the School of Law, and welcome to the first in Conversation with the Judiciary speaker series. We are expecting a full house. There have been numerous RSVPs. We suspect some people are still stuck in traffic, so we will have people trickling in, we suspect, and we hope they won't disturb us too much. Just a little bit of housekeeping, I guess. Bathrooms are through the back and down the passage on the left, and then on the left-hand side if you need to use the bathroom. My role is quite a simple one: is to introduce the speaker series, tell you a little bit about the format, and then introduce our three participants in this evening's conversation. Now, just to give a brief sketch of where the idea emanates from, or why we're having a conversation with the Judiciary speaker series, it can be said that it's uncontroversial that in our Constitution, much power and a great deal of responsibility is placed in the hands of the judiciary. And like all power, it can be used or deployed properly, or it can be abused, or it can simply be misconstrued. Therefore, recognizing the enormity of the task facing judges and the expectations of society, and the expectation that society has of them, the speaker series is premised on the idea that society has an interest in learning more about how justices or how judges exercise the powers entrusted in them by the Constitution. In particular, beyond JSC proceedings and beyond court judgments, which is normally the way we hear about judges and what they think, and when it's judges, it's normally a one-way conversation in inverted commas. Society is interested in knowing how judges think. Society is interested in knowing how judges reason, and in particular, what makes them decide in the way that they do. So to put it simply, living in a constitutional democracy, we're interested in questions of judicial philosophy, particularly in as far as that philosophy relates to the Constitution. So in creating this In Conversation with the Judiciary speaker series, what we seek to create here is a platform where judges from various courts, it's not only going to be constitutional court judges or retired judges, as is the case in this evening, but what we want to do is to create a platform where judges and various other interlocutors are invited from time to time to speak on different contemporary legal matters. And in doing so, what we want to do is to allow judges an opportunity to reflect on their experiences, on their thoughts, and their role as judges in the courts as well as within broader society. And in this particular respect, we must thank Professor Mhango for coming up with this idea and giving us this platform. Now, the way that this particular conversation is going to work, or the format of this conversation, is that we're going to have 90 minutes of open conversation, which will be facilitated by Professor Mhango. The first 45 minutes will be a conversation between our three main speakers, Justice Yacoob, Professor Cathi Albertyn, and Professor Mhango, who will lead the conversation. He'll both facilitate and moderate. Then the second 45 minutes will be open to questions. Now, I must emphasize that we are looking for questions. We're not looking for monologues, statements, soliloquies, you name it. And we would ask that we keep our questions focused on what has been discussed, or at the very least, the questions must relate or connect to what has been discussed. Professor Mhango is going to be the moderator of the questions, and he has said that I must warn that he will be swift and heavy-handed if people stray beyond what we we have been discussing. So there will be an opportunity for us to extend the conversation beyond our three speakers. The last thing for me to do is to introduce our three speakers. Justice Yacoob is probably familiar to most of us as a judge on the Constitutional Court, and he's now a recently retired judge of the Constitutional Court. But I'm going to just give you a brief, a briefish introduction, because he has done a lot in his life. He has achieved an incredible amount, and he has served this country incredibly well. So I'll try and be brief in sketching what is a long and illustrious career in law. In the first instance, education-wise, Justice Yacoob studied for his BA and his LLB at the University of Durban, Westville. He qualified, and then he went on to join the bar in Durban in 1973, where he served his pupillage. He was admitted as an advocate in 1973, where he was then a junior counsel from 1973 to 1991. Some of the matters in which he was involved is that he represented and advised many people who were being prosecuted for contravening security laws, emergency measures, and other oppressive legislation. He was part of the legal team that represented accused persons of the UDF in the Delmas treason trial, and amongst other instances of representing members of many communities, particularly in Durban, who were having problems with the law, and particularly apartheid's unjust laws. In 1991, Justice Yacoob took silk, and it was in 1998 that he joined the Constitutional Court. Now, apart from an illustrious legal career, Justice Yacoob was also actively involved in politics. He was an executive member of the Natal Indian Congress from 1981 to 1991. He was also an executive member of the Durban Housing Action Committee from 1982 to 1985, and he was also active in many other political and social organizations in his time. With respect to his community involvement, he was also involved in the activities of the Natal Indian Blind and Deaf Society. He was also involved in the South African National Council for the Blind, and he was also actively involved in the bringing about of our democracy in quite a direct way, in that he was involved in the constitutional negotiations, having been a member of the Technical Committee on Fundamental Rights, as well as having served on the Independent Electoral Commissions from December 1993 to June 1994. And as I mentioned earlier, he recently retired from the Constitutional Court. If we can give Justice Yacoob a warm hand of welcome. Then we've got Professor Cathi Albertyn. Professor Albertyn is a professor of law at Wits Law School. She teaches in constitutional law and human rights law at undergraduate and postgraduate level. Prior to, moving over to the law school, she was the director of the Center for Applied Legal Studies from 2001 to 2007. And Professor Albertyn has also been a commissioner at the South African Law Reform Commission. Professor Albertyn is widely published both locally and internationally, particularly in the areas of equality, gender studies, human rights, and constitutional law. If we can give Professor Albertyn Then our moderator, Professor Mjendeweka Mhango, joined the School of Law in 2006 after having studied at Morehead State University in Michigan and Wayne State University Law School in the United States. and as well as the University of Cape Town. Professor Mhango researches in pension law and constitutional law, is on the editorial board of the Malawi Law Journal, and currently Professor Mhango is also our acting head of school. If we can give Professor Mhango a warm applause. And that's my job done. I hand over to Professor Mhango and enjoy the evening.
Thank you very much, Sam. I am very honored today to be sitting next to what I call two of South Africa's experts on constitutional interpretation. And so what I'm going to do is I'll go right into the discussion that we should be having today. I'm going to be asking questions to each one of them, and we'll ask each one of them to comment on the questions that I'll be posing. And so feel free to note questions if you need to follow up at a later stage. Let me start with Justice Yacoob. And I want to start with a short story, very short. There's a story that is told of two justices, Justice Hans and Justice Holmes, who had gone out together for lunch. And while lunch was finished, Justice Holmes got up and started to walk so he can leave. And his colleague, Justice Hans, said to him, "Do justice, my friend." So Justice Holmes turned back to his colleague and said, "That is not my job. My job is to interpret and apply the law." So Justice Yacoob, I want to ask you, which one of those two judges are you?
Well, I suppose that in the days when Justice Harms and Justice Holmes had this conversation, I would have been interpreting and applying the law. Because in those days, there was no such thing as justice in our country. There was indeed not even a bridge between law and justice. That was very, very difficult to find. So that I think that I would have been lying if before 1994, if I had been a judge in the High Court or in the Appellate Division, I said that I was doing justice, or I asked anyone else to do justice. There are many judges, one or two of them may be here, I don't know who's here, who did try to do justice, tried very hard to achieve justice as a result of the work they did. And they were wonderful judges who helped us in our struggle a great deal. Half a dozen of them, maybe 10. But for the rest, judges interpreted the law and applied it. Whether it led to just results or not didn't really matter. Now our Constitution is different. Our Constitution requires the Constitutional Court to consider matters when it is in the interests of justice to do so. It requires us to adjust our procedures to make just and equitable orders in a number of different circumstances and cases. And it requires us to interpret the Constitution in a way which accords with its values. And the values of our Constitution are openness, accountability, and I would suggest that our Constitution is aimed at doing social justice. So that today, there is little room for any judge to make a distinction between justice on the one hand and interpreting and applying the law on the other hand. I do not think it is ever possible to interpret our Constitution in a way which would not accord with some notions of justice. But there is a trouble even there, because justice is neither a static concept, nor is it a concept on the definition of which many would agree. And that is why, even though you get two judges applying justice, it will be justice as they understand it in a way. And justice you conceive of depending on where you come from, who you are, and what your life experiences are. The notion that there is an objectively definable characteristic called justice, to me just sounds difficult to accept.
Well, thank you very much for that. Professor Albertyn, what is your sense of the role of judges?
I wanted to take Judge Yacoob, but the rest of us as well, back to John Dugard's criticism of judges under apartheid. And his criticism was, amongst others, the failure to recognize judicial choice and the failure to recognize the inarticulate premise, which is that we all have values and ideas and philosophies which we interpret the law in accordance with, but that we aren't always honest in the fact that we do that. And that what the Constitution should allow us to do is to interpret the law in line with an explicit sense of what those values and principles are. So the Constitution gives us those values and principles, but also I think with an honesty about what our own internal premise is and our own internal predilections. So can I also ask a question to Justice Yacoob? Because I'm really interested in the judicial process then. Because the judicial process has to be at least about two things if the interpretation of the law is going to lead to some sense of justice, contested as it might be under our Constitution. And the one is that judges need to be open about their interpretation of the vision of the Constitution, whether that's transformative constitutionalism or something else. And the second is that judges need to be honest about their own personal moral philosophies, because the two of those might conflict and you might have to work to make them develop in harmony.
Now, I agree with that completely. People express the notion sometimes that judges are objective. Some judges believe that they are being objective. My own belief is personally that it is quite impossible for judges to be objective because they are to a degree subjective. And the real question to be asked is whether, or the degree of subjectivism that is appropriate, because an entirely objective decision is also not appropriate in cases where one is judging things which has implications for human beings. And I think that the judge who believes that he or she is objective runs into the danger of being subjective without knowing it. So all I can say in answer to that question is that I'm very aware, always acutely aware of how my own sense of how I want things to happen would come in my way, as it were. But I try very hard to let my propensities matter as little as is possible in the circumstances, and try to interpret the Constitution. Now, of course, I interpret the Constitution in a particular way, and I embrace all the values of the Constitution, with the result that it very seldom happens, from my perspective, that an interpretation of the Constitution would be against my moral values. My moral values, and I've gone into them quite carefully, reflect the values of the Constitution. I believe in equality, I believe in affirmative action, I believe in the kind of social justice which our Constitution prescribes. I have a passion for deepening human dignity, and so on. So really the idea of my moral values being in conflict with the Constitution is neither here nor there. Sometimes it happens that not really moral values would come into it. Sometimes you would like to interpret the Constitution in a particular way because you have a preference for a particular way of doing things, and you can't really get there. And then you interpret the Constitution, some people may say conservative. And that would have happened to me in a case like Dr. Stolat, for example, where I would have liked to hold that the legislature must consult first because it was the right thing to go for. Really have liked to find it, but I found it completely unable to do so in the light of the structure of the Constitution as it was.
Thank you for that. Let me just maybe change it a little bit, and because Yacoob, you mentioned the historical aspect here, and I wanted to say that the country now seems, in my view, more politically polarized than at any other time in post-1994. And I'm wondering whether, does this polarization, if one agrees with me and engage with me on this one, does it present any special challenges to the judiciary?
Where the Constitution is not involved, it might present a particular challenge when plain politically unjusticiable disputes are closed up as justiciable matters before a court. And I think court must be careful to avoid being led into a situation where a political unjusticiable issue is being regarded as a justiciable one. So the starting point, of course, is that Section 34 gives people the right to have only justiciable disputes determined in a court. It doesn't say that these disputes must be non-political or even have nothing to do with religion or something like that. What Section 34 talks about is justiciable. Doesn't matter what the dispute is all about, as long as it is justiciable, a court is obliged, the parties come before it to look at the dispute and find and decide it. As far as our court is concerned, our jurisdiction is limited a little bit more to justiciable issues because, again, I don't think any court can ever determine a matter which is not justiciable. So our jurisdiction is limited to justiciable issues, but even more limited to justiciable issues concerned with the Constitution. And our Constitution is plain that the government may not violate the Constitution. Nobody may violate the Constitution. And it's our job to make sure that the obligations imposed by the Constitution are adhered to. So whether it's a political policy question or it's a political dispute, my own view is that leaving aside the wisdom or otherwise of the parties who bring the matters to court as to whether they should have brought them, our duty as a court is to adjudicate justiciable issues when we have them before us, and to adjudicate them honestly and properly, particularly where they concern constitutional matters. There's nothing in the Constitution that says that we must have regard to whether a matter is political or not before we decide whether it's a constitutional matter which we might adjudicate.
Thank you. Professor Albertyn, would you agree with Justice Yacoob's views on this?
Yeah, I mean, I think when you were talking about political polarization, a number of things crossed my mind. I think the one thing is the danger for the courts when they're drawn into political conflict. So, however carefully the courts try and adjudicate it and maintain it in line with the rule of law, I think there's a real danger that courts get seen to be either overly independent or not independent enough. And there's a real danger for the legitimacy of courts. I think it becomes a much more dangerous territory in terms of winning over the public. So I think that's one problem. I think another problem, and it's not so much about political polarization, it might be more about value polarization. I think that in the early 1990s, we were much more confident with the court that we had and the fact that we were coming out of a constitution process that bound the community together, that there was some kind of consensus around the progressive social democratic values that were in the constitution. We might have been naive at the time, but I think we believed that in fact the notion of transformative constitution, the notion that it stood for a particular kind of advancement of our society and that the court would play a role in that, and that the court appeared to endorse it in Yacoob, Justice Yacoob might want to agree or disagree with that, suggested that there was some kind of value consensus in South Africa, but I think it's become more and more apparent that there isn't that value consensus, and that the vision of the Constitution and those kinds of values are more and more contested. And as the composition of the court changes, I wonder if they aren't more and more contested within the court itself. So that certainty around a particular social democratic project that we might have had earlier on, I think is a declining certainty now. I would be interested in Justice's comments on that.
Good, and I want to ask you a question too. But the thing really, it is publicly perhaps apparent that the values are more contested now. But we as a court were always aware that these values are contested. We're always aware that this is the reason why there are 11 judges in the court. And there are 11 judges who come from different places, who take each other seriously, who have previous lives. And we try as a constitutional court to overcome that problem by taking each other always extremely seriously. So when you're in a court like the Constitutional Court, which is a collegiate court, you cannot be really the kind of person who relies too much on your own sense of correctness. Collegiality means that you've got to talk to people, you've got to take what they say seriously, you've got to think about it very carefully and try very hard and disagree only if you have no option but to agree. Quite often we find in talking with each other that there are debates, but if we take each other seriously, we can often include the other point of view in a majority trial, which becomes richer consequent upon that. So that very often happens too. Now, of course, these values are perceived differently by government. So government will sometimes feel that some of these judges are not right, and they would lie to appoint constitutional court judges in particular who would agree with the values as they perceive them. It happened in America, and I have no doubt it happens here. The power to appoint a president is that, or the appoint a constitutional court judge, is that of a president. It is the president's power alone. The only restriction is that he needs to appoint from a list of 4 people provided by the Judicial Services Commission. And in the nature of things, the president is likely, and I don't see anything wrong with that, to appoint judges who he or she thinks might agree with the constitutional values as they perceive them. But there's a problem with that, as has been shown by experience elsewhere. Presidents can quite often be mistaken about these things. And things change, there are always other things, and so on. So it's really quite a complex thing. But our appointment process is such that the president appoints members of the Constitutional Court. It is possible that the Minister of Justice can wholly influence the Judicial Services Commission, which could make a recommendation to the president on the basis of what the president wants to hear, not as a result of any ill will, but quite honestly applying their minds to the question. So I think that's the short answer. The question I wanted to ask you was, do you agree, though, I mean, as difficult as it might be for the courts and so on, that once there is a justiciable constitutional issue, we have no choice but to deal with it? I mean, we can't have a discretion not to deal with the issue because it might bring us into a bad light somewhere along the line.
No, I agree with that, because I think that's what helps build your legitimacy. Although, justiciable, of course, is also
But nothing.
not a certain concept, but that's being
The problem is that there is no concept in the world which is certain. And that's really part of it. I mean,
people want to know the law is certain.
well, that is why what we try to do is give it some certainty. You have 11 judges to try and overcome the uncertainty problem in the highest court of your country now. And how certain can you get that then 11 of those judges agree, which happens in many cases. And quite often, the government and others disagree with the judgments, even though all 11 judges who have come from different parts of life and so on have agreed. So everything depends on context. Context is everything. Everybody views context differently. Everybody can't avoid having their own experiences, but you've got to have some mechanism. But you've got to remember that judging a case is, thankfully, a little bit different from repairing a motor car. You might have a little more certainty if I might put on the gearboxes in two cars in precisely the same way with precisely the same accuracy. I might not write two judgments in the same way either because they differ very much from each other. So we must accept that we are not involved in an objective justification process. We are not involved in a mechanical process. We are involved in a process where many values are involved in relation to which there are lots of differences, and all we can do is be aware of them. And the more aware we are of that, the more difficult our task actually becomes, and we have to do it.
But I would like to just challenge this notion a little bit here, that there is a view from some constitutional scholars who say that some of the cases that have gone to the Constitutional Court, for example, the political disputes among political parties in South Africa, the ANC, COP, some even cite the case of the outer case, the ETO case, that those cases particularly dealt with political questions that should actually be resolved in the political process and not in the courts. And so if you bring in the notion of justiciable questions, I mean, it's a fluid notion that, but if there are certain questions that even the court itself cannot really give a final answer.
Well, of course, there are lots of questions like that. I mean, if there's a debate between two people about whether God exists or not, that's certainly not a justiciable issue. But if there's if a political party has a constitution, and somebody says you didn't comply with the constitution, and somebody else says I did comply with the constitution, you cannot say that that's not a justiciable issue. Whether a politician should wear a grey suit or a brown suit in court, in Parliament, is not a justiciable issue. Whether they should vote by raising one hand or two hands or three if they have them, is not a justiciable issue. But really, the questions that we had were all about the application of laws and the actions of the executive in relation to which the court was obliged to make a finding. And the best way to determine it is, in one of those cases, try hard, where we found issues justiciable. Make your criticism by writing a contrary judgment in which you say this issue is not justiciable at all, and see how you get it. You see, it's very difficult.
Well, speaking about appointment of judges, I mean, both of you have been very expressed views about the appointment of judges to the bench. You've been very vocal about it. And I wanted to know, I mean, do you believe that that the appointment of judges is too politicized, or do you think that we should be relooking at our appointment process? Maybe we can start with you, Justice.
Yeah, I think our appointment process is somewhat flawed. As I understand it now, they vote on them. And each person in the JSC votes. Now, I would have thought that the appointment of judges, and I'll be writing about this one day, this is practice for writing an article. I would have thought that the Judicial Services Commission would sit down, that the appointment of judges can't be dependent on the views and feelings and thoughts and subjective things of the moment of what the people in the Judicial Services Commission are thinking then, or on what they have for breakfast. Surely there should be a mechanism. There ought to be guidelines. There ought to be some training in relation to how you apply those guidelines. And shouldn't they decide how they're applying those guidelines and write more or less a document to make it quite clear. These are our guidelines. We're applying it's not a subjective thing. It shouldn't be a subjective thing at all. The Judicial Services Commission, I'm quite sure, should have guidelines which it must apply with discipline and care and take decisions on that basis. I doubt whether the Constitution ever intended that the members of the Judicial Services Commission could vote subjectively for the candidate they preferred, regardless of any objective evaluation. Now, of course, I would agree immediately that you would never eliminate the subjectivity altogether, but the disciplined application of guidelines by a very important body in our country will reduce the level to which subjectivity applies sufficiently for us, I think, to be comfortable as a democratic society.
Professor Albertyn, is it constitutionally problematic that the JSC is made up of the majority of politicians who make up the JSC?
Constitutionally problematic? You know, I think many different countries have different ways of choosing judges, and some countries have politicians choosing judges. So, you know, I think it's how you would want to interpret the Constitution. I think in the past, the JSC has worked. So it might be the nature of politics rather than the presence of the politicians. If you could be more confident that the politicians would be voting with a certain degree of oversight, if you like, and independence, rather than as I suppose, as a caucus, then the presence of politicians would be that problematic. But I want to talk about it in a slightly different way. I mean, my problem with the JSC is that it's become a committee that is reproducing a certain kind of judge. It's not appointing women, and it's not always appointing progressive judges. It seems to be tied very much to a kind of a race, gender, value matrix, if you like.
And you can't say this, but what about academics? We've not had appointments from that
Not had appointment academics at all, no. And I think that's problematic. If you take the non-appointment of women, I think it's a problem that the JSC has not acted more strenuously on that. When we had Bridget Butler as Minister of Justice, there were many things she didn't do, but what she did do is she had the political will to ensure that women were appointed. And together with Arthur Chaskelson, who was Chief Justice at the time, there was a political will in that committee to try and actually have a more gender-balanced judiciary. That seems to have completely disappeared. There seems to be the imposition of this criterion of acting, that in order to become a judge you must act, yet of all the acting appointments that have occurred, only 9% have been given to women. So that immediately becomes a huge barrier for women to become judges. So I absolutely agree with Justice Yacoob. You need to have clear, defined criteria. You need to act in terms of those criteria. You need to be confident that the politicians are acting in terms of those criteria and not in terms of some caucus. And you need to make sure that there aren't invisible barriers that exclude certain groups from consideration.
I should disclose that in 2012 I nominated a woman to be a judge on the vacancies, but she was never given shortlisted.
Maybe that was because you nominated him.
So, and I think this leads me to the question that is there anything that the public can, any role that the public can play in the appointment of judges? Is there any greater role that the public can play in the appointment of judges beyond the JSC?
If this clarion call made by Cathi and I today about guidelines can be echoed everywhere, all over the place, it will be a very important role. If all academics and university people and lawyers start insisting on the NADEL and the Democratic Lawyers Association and all others began to insist on this, it might well make a difference. And if we talk about it everywhere, talk about it to our students who when they grow up start talking about it, might make it. There's a big role for civil society to play. We must just be able to organize and play that role. Which hopefully I'll have a bit more time to do now.
In every country where women have been appointed, it's been because of political activism.
Yeah.
So there's no question that there's a role for civil society to play.
And you see that the reason why women have been, shall I say, recognized appropriately and properly in the Constitution, in my view, is not because the men in the ANC at the relevant time were very giving and wonderful and understood. The real reason is that the women in the ANC were too strong for the men.
Now, I want to just move on to something different. There are some societies that believe that unanimous decisions by the highest court are the most effective way of society to be governed. And that you will find that in those societies, you hardly find any split decisions. I can tell you one example of the country, neighboring country, Malawi, where you will never find a dissenting opinion from the highest court of the land. But of course, the situation in South Africa is different. We do have lots of split decisions. But I wanted to find out, Professor Albertyn, what value do you think that split decisions offer to South African society?
I mean, other than when they're losing decisions, they often have value at all. I think split decisions are democratic to my mind. I think they show people that judges don't just make and interpret the law, that there is not necessarily a single interpretation of the Constitution, that the Constitution is capable of diverse interpretations, and that's not a bad thing. You know, our president, I think, last year thought it was a bad thing that judges disagreed. I think it's a good thing that judges disagree with each other. I think it makes for a vibrant democracy. I think it gives us different understandings of ourselves. We just don't like it when we're on the minority side. So I think there's absolutely space for split decisions, for dissenting judgments. There's that old adage that dissents of today become the majorities of tomorrow. I think there's also a place, though, for the unanimous decision. And when I teach my students the Muhammad case, which is about the rendition of Mr. Muhammad to New York to stand trial without first getting an undertaking that he wouldn't get the death penalty. That decision is written in the name not of the individual judges but of the court. And I think that was a sign of the immense disapproval of the court of government's actions in those particular circumstances. So I think also the consensus decision, I think, is also very powerful for
Just as Yacoob.
But if people agree, they agree. If they don't agree, they don't agree. And you can't force somebody to agree with something which they don't agree with. That's the first thing. There are jurisdictions in which they say you vote, right? And let's say the vote is 6-5. Then the judgment of the majority just comes out. You don't get the reasons of the minority. That is difficult. That's highly complicated, because one of the important things is that law also develops slowly and carefully, incrementally as it were. And the dissent of today is quite often the majority of tomorrow. So the dissent quite often points the way to begin with the law might in fact develop, which I think is also quite good.
The question maybe is how much space there is for these concurring and separate opinions. Of multiple
that's a very
judges.
important question.
Yes.
Multiple judges saying, I agree with everyone, and let me explain how.
Now, one of the cases, Justice Yacoob, that you dissented was the Glenister case, which was decided 2 years ago. And you were one of the dissenting justices. Now, in that case, the majority of the court ruled essentially that that the Constitution itself imposes an obligation on the state to establish a body that would combat corruption and organized crime. Now, I must say, for some of the audience who might not know, that the case dealt with the issue of the scorpions in the books. And this case started from all the way from the ANC's conference in Polokwane, where a decision had been made that the scorpions had to be disbanded and replaced by a different body to fight corruption. Now, in the media, the spin on the story was that this new body would protect certain politicians. And I think the perception had been developed along those lines. Now, the difficulty, I think, that emerged was that the decision in Glenister, many academics and commentators found that its reasons were not well articulated, but the outcome had been accepted by many. But the question I wanted to put to you is, and I think the perception was also that the court in its judgment had essentially endorsed or ratified these perceptions that had been developing in the media around why the decision had been made to disband the scorpions. So the question, I think, is how does one go about convincing the public to retain the confidence in the judiciary when unelected judges invalidate laws that do not conflict with the text of the Constitution? Because as far as I'm aware, in that particular case, there was no specific provision in the Constitution that had been violated. How do you justify that?
Well, firstly, I was in the minority in that case. But leaving that aside for the moment, let me tell you about my role as a minority. This was, to me, one of those cases, and I'm not talking about any of my own colleagues, all. This was for me one of those cases in which I was very strongly tempted to join the majority because of my revulsion of corruption and because of my very deep concern that corruption was a cancer that was going to kill our society inevitably. And that is why a stronger mechanism than was allowed by our Constitution, in my view, was required. It was one of those classic cases in which I was very tempted to go the other way. But it was one of those cases where I couldn't do it. So that's an interesting thing about that case. The question you asked, firstly, unelected judges is a bit of a trouble for me. Because you've got to go back to where judges acquire their authority from. Our Constitution was established and accepted by 90% of an elected constitutional assembly. It is that Constitution which provides that its obligations must be obeyed. It is that Constitution which provides that the Constitutional Court judges have the power to make a final decision on these matters. And it is that Constitution which was adopted by many, many, many people, 90% of the people, that gives us that power. And it is that constitution, which has been accepted by 90% of the people, would provide that that power can be taken away only if 75% of the population vote against it. So we have a democratically conferred power. And if one understands that I don't have it anymore, thank God. But if we understand that power as being democratically conferred, then it is wrong to refer to these judges as merely unelected judges. They perform a constitutional duty. They have a very difficult duty to perform, and it's sometimes very difficult to do it, but they are doing so in terms of the Constitution and in obeying the dictates of a Constitution which was passed by 90% of the electors. So until that Constitution gets changed, that's the end of the matter. But the politicians, the elected representatives of the people, have the power to change the Constitution if a sufficient majority of people support it. But until that happens, the Constitution, for better or for worse, stays.
Professor Albertyn, Glenis, what's your view on that case? Given, I think the scenario to me is that in Glenisa you had elected representatives, the people, through Parliament, pass a law that no provision in the Constitution said they cannot pass. And yet the court says that we think there's an obligation in here that the framers of the Constitution included in here, which we think that this law is unconstitutional. What's your view on that?
I like it. I probably like it for the wrong reasons. But I think the majority over many pages made a solid attempt to justify it in terms of the constitutional text. It would be incorrect to say it stood outside of the Constitution as if there was no constitutional basis for that judgment. They tried very hard to find a constitutional basis. They tried very hard in terms of Section 7. They tried very hard in terms of the interpretation of international law. We might disagree with it. It might be overturned. Many people might argue that it's a wrong interpretation, but it was an attempt at interpreting the Constitution.
And it was brilliant.
And I think we live with those in a constitutional
The majority agrees with it. So, I mean, the fact that, I have to live with it too.
Justice Yacoob, how do you react to the term activist judge?
I think there's no such, the term is quite brilliant. What we do is we apply the Constitution to the best of our ability. Some of us interpret the Constitution a bit more generously than others. Some of us have a broader interpretation than others. And I think that the activist judge was a thing that came from the past. It came from America. In the past, we did have activist judges who stretched the point, to achieve justice in our country. Now we don't have to stretch a point to achieve justice in our country. The Constitution requires us to achieve justice. But it may be that some of us have different notions of justice, and that might give rise to some judges being more generous than others, and those judges might be referred to as activist judges. But I don't believe that unless you define it like that, there are creatures like activist judges.
On activist judges? Well, I think depending on the interpretation of the Constitution you take, you might see it as your role to be an activist judge in the sense that the Constitution is there to transform our society. So the Constitution for many people is a document that sets up a vision that is about fundamental change, and that's about the achievement of equality, the achievement of dignity, greater freedom, reduction of inequality, achievement of socioeconomic rights. And the very notion of transformative constitutionalism, at some level, is a notion of activist judges.
But then
it's
all
a
of us
notion
have
of
to be
judges playing a role. But activism is not necessarily a good thing. Activism works both ways. Activist judges can be very conservative and can take you backwards. And I think one of the problems with the use of the court, and it partly goes back to your political question, Dr. Maybe, is, for me, it's a problem when the court is seen as the only solution. In other words, that everything lies in the domain of courts and the domain of law. And that leads to a distrust of democratic politics. And I think in South Africa we need both. We need both the use of the court, we need both law, but we also need democratic politics. And it's the more libertarian organizations, if you like, I think, that fundamentally distrust democratic politics, so only go to the courts. Whereas I think the more progressive organizations are actually trying to use both. They're trying to use politics and democracy.
What we can think about there, I think many of you know that we have a chapter in our constitution called cooperative governance. And that applies to disputes between provincial and national government. And unless the court is satisfied that provincial and national governments have tried hard enough to settle the dispute amongst themselves, the court is entitled not to hear the matter and has the discretion to refer the matter back to them to say, try harder to settle this dispute, we're not touching it. And I don't know, people who are thinking of future constitutions and future amendments might think of the notion of giving the courts the discretion to refer matters back to people, even if they are justiciable disputes, if they have not tried hard enough to settle it. There are cases where we've said, for example, in socio-economic rights and housing cases, that people must engage with each other properly before they come to us, and we'll take that into account. That may be some kind of starting point. But maybe this is an idea around which a constitutional amendment might be quite useful. And depending on, and particularly now when the majority in the ANC has suffered a defeat as a result of our court deciding a political issue, they might be very happy to accept it.
Now, Justice Yacoob, do you then believe, and I've heard this others in South Africa mention it, but do you believe that the Constitution is a living document that changes over time outside the amendment process?
Yes, I do. I don't believe, I was going to come back to you, I forgot about that, but you give me the opportunity to do that. I don't believe in the intention of the Constitution makers at all. I think that that gives rise to a rigid Constitution, which has to be amended each time, particularly as far as the Bill of Rights is concerned. Words are capable of different meaning, and we've always said, you'll see that although we have not in our judgments ever disavowed the notion of the intention of the makers of the Constitution, I don't know whether any academic has picked it up here. We have never in our judgments tried to ascertain the intention of the Constitution. We have always said as a court that words mean different things to different people at different times. And there's no such thing. I mean, each of the Constitution makers, when they were voting on that thing, might have been thinking of different things when they were drafting it. For all I know, a quarter of them might have been asleep. For all I know, half of them may not have read the constitutional text before they voted on it. And therefore, to talk about the intention of those who voted at the constitution making is not very accurate. Then to talk about the intention of people who drafted it, like me and so on, that would be particularly dangerous, because the intention of the drafters have nothing to do with it. It's the political will of the people. They voted for it. So it's not accurate even to talk about the intention of the makers of the Constitution. I think context is extremely important, and I think that Constitution generously interpreted may mean different things, but the context must change sufficiently to form an extremely cogent for the change. Because as I agree with Professor Albertyn, that there must be certainty. But of course, the real difficulty, I think, as Professor Albertyn would agree, is that there must be a proper balance between certainty as far as the law is concerned and change as the morality of our society changes and as society requires the law to be somewhat different in terms of their own thinking of it. These are hard questions.
Thank you. Professor Albertyn, just on this question of the living document, I think the notion that Justice Yacoob mentions about disavowing the intentions of the framers of the Constitution. But if you could address it, but I want you to think about this. The court itself, finally, in deciding the question of the death penalty, did in fact go and looked at the deliberations of the framers of the Constitution, and in fact laid out the principle that we can look at the history of what the debates were like, what was said, and so forth, in trying to determine the meaning of the provision of the Constitution. But how would you respond to Justice Yacoob's?
I don't want to extend it since then.
No.
Yeah. I mean, I agree with Justice Yacoob. I think that original intent is a misnomer. I think it's a foreign concept. I don't think it's a South African concept. It's an American concept of 200-year-old constitution. I mean, as if you could know what people meant 200 years ago, except that slaves and women didn't have a vote. So I don't think that it's about original intent. I think if you were present at the constitutional negotiations, I think Justice Yacoob is quite right. People understood different things by that text. On the right to life, the National Party, I'm sure, understood it as not as allowing the death penalty and prohibiting abortion. On equality, I'm sure that the Democratic Party wanted to understand that as placing very narrow constraints on affirmative action. So there is no such thing as original intent. That doesn't mean to say that history is not important. But that's not history necessarily only in terms of what the framers said at the time that the Constitution was written. That's history in terms of understanding where our Constitution comes from in our society, and in terms of our ethos and our past, and how the Constitution turned its face against a particular past towards a more democratic future. And that takes us into all kinds of discussions around bridges and metaphors and transformative constitutionalism, which maybe they want to take up in discussion.
That's right, and you see, in 1996, that history was important. 1997 or 98, remember that decision? 1994, that history was extremely important because nothing really meaningful had happened in our society since those discussions. And as I understood my point here, they were taking into account that discussion as throwing some light on the meaning of the provision, not for the purpose of determining what they intend, but rather taking it into account and deciding whether that has implications for the interpretation of the provision. As I understood it, that's what they were doing. And as I understand it, as time goes on, those discussions remain important, but somehow could become less and less important if other developments in history have overtaken them or modified them or provide a reason to pay less attention to them.
Thank you for that. I have one more question, and then we'll come to the audience. So be prepared with your questions. And my question is to Justice Yacoob. Can you share with us any one of your memorable moments in the courtroom?
The whole time is memorable. I can't think of any moment that was particularly more memorable than any other. It was all a wonderful time.
Okay. But if you were to write an article or a book about that one case, what would it be?
I won't try. Because I won't know what it is going to be.
Okay, well, I will now open this up to the audience, and so I will take maybe 1 or 2 or 3 questions in advance, and then we'll have the panel give answers. I see a hand over here, and there's one here and one in the middle.
Thanks very much to the panel. This is a question. I'm Jackie Dugard from SERI. This is a question to Justice Yacoob. Justice Yacoob, the Constitutional Court Socioeconomic Rights record has been criticised by a lot of people for being not radical enough, and definitely not as radical as in other emerging democracies, such as in Latin America, for example. There have been various reasons posited for this, and this is going back to what you opened with about the inarticulate premise, judicial reasoning, etc. I was wondering on your thoughts. I mean, some of the reasons posited are a culture of legal formalism in South Africa, lack of radical training, especially on socioeconomic rights. Also, the theory that maybe the court was trying to do a balancing act with the executive, as it would have to do in any country. I don't know if you think any of these reasons resonate, or indeed all. Thanks.
Yeah, but
Take 2. Yeah, and take one more right here, right there.
Thank you. That was really fantastic to listen to. I have a comment and then a question that follows. Justice Yacoob was particularly frank in indicating that the concept of justice maybe had elements of subjectivity, and that in the process of adjudication, it was inevitable that a judge would bring his or her own subjective reflections to bear. And yet it was interesting in discussing your dissent in Glenister and in Doctors for Life. You indicated that even though you had a strong subjective preference for the opinions of the majorities, you found yourself unable, as a matter of constitutional interpretation, to agree, which suggests that that the process of adjudication is not simply subjective. I think that's very important, because a distinction between subjective opinion of judges and, I mean, it's a sort of traditional argument, if you like, but and constitutional law on the other, I think is important for the legitimation of the project of constitutionalism in South Africa. But here's my question. So we need some conception of law, even if it's value-laden and has a transformative purpose and so forth. What counts as law? But judged from the other side of that equation, the distinction between law and politics, I think the issue that Cathi raised was very important. What is the role for and space for democratic politics in a constitutional order? How, if constitutional adjudication inevitably involves elements of subjectivity and disagreement, do we distinguish law from politics? And so the question I have for Justice Yacoob is that even if we can make the argument that constitutional review has been legitimized in South Africa through a democratic constitution-making process, it doesn't entirely displace questions of the counter-majoritarian difficulty. And so the question is there a case to be made for judicial restraint in order to create space for democratic politics? Because that seems to be the premise, if you like, of this whole initiative.
Thank you for that. I think let's address this, and then we'll go to another round.
let's go to the last question first. Of course, there's need for judicial restraint. And that means that when you decide the case, you take into account the political nature of it and order something different from what the majority require only if there is a very cogent case with it. That's the judicial restraint that is required there. It's a different judicial restraint from one which says we must not deal with these cases. You can say to people, don't bring those cases because we don't want judges running our lives, and they mustn't bring them. That advice may well be good. I might even advise people in certain instances to do that. And I think people may be incorrectly advised. So I completely accept that in certain kinds of cases, you require a more cogent case. One wouldn't go into it. Again, things would differ. Right? Some people might go into it easily, but I wouldn't go easily into it unless there was a very cogent case for a party to win the case. That's the extent to which I think judicial restraint remains important in these kinds of cases. But you can't say, I refuse to decide this case when there's a debate about whether X and Y have complied with the constitution of a particular political party or not. Unless the constitution of that political party itself sets out some restraint or constraint and so on and so on. As far as the other question is concerned, I agree that our courts have been conservative, and I think rightly so. Courts are usually conservative. Socio-economic rights is a new area. It does involve a new conception of the separation of powers. It does involve new areas of adjudication of which we really don't have enough experience yet. And the chances of going wrong and treading too much into the executive sphere in certain circumstances are high. And in those circumstances, I agree that what the Constitutional Court has done so far is that it has moved cautiously and carefully into an absolutely unknown area beset with many, many pitfalls, which we can't see and we can't really understand yet. But I think that there's a lot of scope for development of this law. And I would advise people not to see where we have been wrong. There have been many cases in which we've given pointers to people, and academics and lawyers can write articles on how the various pointers in various constitutional court judgments can be used to take socio-economic rights further. I think it's a much more useful debate than to think about why the Constitutional Court has been cautious. I think a better way is to say, yes, they have been cautious. The reasons they have been cautious are these. It's our job to try and get them to be a little less cautious. We're not going to get them to do everything we want. But let's see, where are the positives which we can use to develop the jurisprudence further and enable this Constitutional Court and other courts to imaginatively and creatively go forward relatively slowly in making socio-economic rights a reality.
Yes, Professor Albertyn, if you could come in there.
I just want to add a couple of things mainly on Feroz's point, but I think they talk a little bit to Jackie's point as well. And that's on the law-politics divide and democratic politics versus the court. I don't think you should always see a bright line between them. And I think that the remedial power of the courts particularly has been, and could be also, has been creatively used to try and develop a relationship between courts and politics. So in other words, that courts can enhance democratic deliberation and can enhance democratic politics. The one example that I think about, although it's not the best example, is the remedy that was given in the Fari case, which is the case on same-sex marriage, where Cato Reagan, in a very principled minority judgment, said right should be vindicated right now, and you should develop a common law and give people the right to marry now. Whereas the majority, in terms of Sachs, said no, this has got to go back to the democratic process, and forced Parliament to take it on. Now, a lot of people didn't like the majority judgment and thought the minority was principled and correct. And yet the majority judgment was in many ways the wiser judgment, because it forced the African National Congress to take on the responsibility of passing a law that would legalize same-sex marriage. And I thought that was, in retrospect, a very wise decision. And I think there are other examples. And I think in the area of culture and religion, particularly, the use of the remedial power, the use of throwing it back to communities, of throwing it back to Parliament, the suspension of the declaration of invalidity and throwing it back to Parliament, all of those are ways of building up the democratic process. And I think the court has often been quite successful in doing that, and I think it's an avenue that the court could explore more.
I agree completely, but I would like to ask a question. Do you think you question whether the law that Parliament ultimately passed after the Fourie decision is sufficiently interesting to warrant discussion at some time?
People have written about it. People have written about it.
I think that it is warranted for discussion, and civil society is comfortable with the constitutional arrangement. I think everything should be up. And I believe that even when the court decides, the matter is not over, because the constitution can always be changed. And so the discussion in society must go on. As now we must go back to the audience and get another question.
But the constitution won't be changed to that extent. I mean, I challenge any lawyer here to try and write a judgment on that constitution which says that it would be right not to allow gay and lesbian people to be married in our society. I'd love to see it. Quite impossible to write.
Yes, in the middle of it,
My question refers to a critique that one hears about the Constitution. The critique goes something like, the Constitution does not reflect the values or maybe the public morality of the majority of South Africans, but rather it's a document which reflects the values of just the liberal elite or the enlightened ones. So it is in some way imposed on the majority, on the majority of South Africans. One hears this critique mostly when you're dealing with issues like homosexuality, constitutional provisions which deal with abortion, and to a certain extent, the property clause. So my question would be, if this critique has any merit at all, isn't the legitimacy of the Constitution at risk if now the majority of South Africans feel that the document does not reflect their values?
Well, the majority has a couple of things they can do. They can start organizing and mobilizing to change that constitution. Because if they believe that 75% of the people don't want it, they should be able to organize and mobilize. Then we have a different constitution. If the majority says we don't want a constitutional court, the majority can equally mobilize and organize to get the constitution changed. And then you won't have a constitutional court at all. So the majority today has power. So there's no point in going on with the debate and so on. We have a constitution. And it's the only way to do it. You can't determine things by what people say, people's opinions on what the majority think from time to time, and on surveys and so on. We have a particular way of doing things. And my only answer is that until and unless that majority can organize and mobilize sufficiently to get that constitution changed, we are required, all of us, to obey that constitution, enforce it, work in terms of it, and try to achieve its values.
Yes.
follow on this conversation, Judge, would you agree with the proposition that in fact we don't have the type of democracy in this country that entitles a majority to make a decision that, I mean, you would have to agree with the proposition that it's curtailed, decision making is curtailed by the Constitution. So it's not about that the majority of the country would want something, but whether it's consistent with the Constitution. Hence the Makonyane judgment and the reasoning by Chaskelson, where he was at great pains to say that even though public opinion weighs in favor of the death penalty, that the court can't give in to that public opinion because it's the majority opinion. Your suggestion is if the majority is that unhappy, they must mobilize and change the Constitution. Do you agree with, I'd like to know what you think about what is called in India the basic structure doctrine, and whether there is any part of the Constitution and any sort of the core values of the Constitution that can never be amended, as is suggested by some constitutional scholars and previous former judges in India.
Yeah, I think in our Constitution it's a little bit different, and we are limited in the application of that philosophy by that provision of our Constitution, which says Section 1 can be changed by 75% of the people. So I think that once that Constitution, and Section 1 does represent the principles upon which our Constitution is based, and I think that the proper approach ought to be structures rather than principles. However, I mean, one can only answer these questions by going into hyperbole of one sort or another. But I would suppose that no court in this country would uphold an amendment of the Constitution which says, for example, that all Muslims must be killed on sight. I mean, even if 99% of the people in Parliament or in the National Assembly voted for it. So I start with the notion that there must be something which Parliament can't do in relation to amending the Constitution, but say with a sense of relief that I will never have to decide where that boundary actually lies.
Yeah, Professor Albertyn, if you could come in there.
I want to make a couple of comments. I mean, it worries me when people hone in on same-sex marriage or abortion as examples of the Constitution being foreign and not resonating with South Africa. It's often done, and I'm not saying at all that was what the questioner was doing, but those issues are often used for quite populist reasons. And while it represents the fact that our Constitution is there to protect the vulnerable and that we should never change it, our Constitution is a much richer document than two issues. And I think if you looked at the Constitution and looked at readings of the Constitution that saw the groups that it was trying to protect, the poor, the excluded, the marginalized, the vulnerable, I think you would find that its values resonated or could resonate with the majority of people in this country. So I think that's the debate that has to be had in a way. The debate about what the Constitution as a whole, read across the whole, means. What do we mean by the achievement of equality? What do we mean by human dignity? What do we mean by freedom? What do we mean by the rule of law and the ability to curtail state power? How does the Constitution protect us against the terrible abuses that we are seeing by the police today? How does the Constitution protect us against the police state, against apartheid reappearing in other forms? That's the conversation, I think, that we should be having, rather than just honing in on particular controversial issues. Because those vulnerable groups are able to come into the protection of a more universal Constitution.
I agree completely, and I want to add just three more things. The first is that you never know what society will ultimately turn out to be. We all know that gay and lesbian people are particularly vulnerable in the sense that there is very powerful opposition to them. I would not say majority opposition, and I don't say majority opposition quite deliberately. The opposition is just hugely powerful. Heaven knows what the situation would be once gay and lesbian people feel more secure, there are no power interests, they'll keep keeping their jobs, society becomes a little more open, and so on. We might have 55% of people who are gay and lesbian in our society. Make no mistake about that. So we don't really know where the majority lies at the moment because of the fact that power interests actually lie elsewhere. The second point I want to make is that the ANC has clearly said that it is against the death penalty, and the majority has continued to support the ANC. I think it was Patricia Jalil's party, which was for the death penalty. And I don't remember that they got too many votes as a result of this. The ANC, it was the ANC that passed the bill which said that gay and lesbian people can get married. There was an election in 2009. I don't think they lost too many votes as a result of that. So I think one must be very careful when we're talking about majorities and what they say. And things change. It's true that from time to time when there are huge murders happening and so on, people claim to be the majority, you get a particular vibe and so on. But we as thinking human beings must be a little bit careful and not be carried away by a particular vibe of a particular moment. Humanity is very interesting. Humanity is caring. Humanity requires careful attention. So I think we must be very careful.
Okay, thank you for that. And just one point on the property laws issue. I'll just invite some of my students in here to go and look at section 25, subsection 8. There's some interesting language in there about what the possibilities are for the state. I would like to invite some more questions, if I may. Yes, right here, in the middle here, right.
I will stand in my culture. I will stand when you ask a question. My question to Justice Yacoob is in connection with black judicial behavior. It is just going to be unfair to you because I would like you to answer a question where I isolate when I say black, I mean judges of African extraction. Would it be prudent for black judges that they must not be hesitant to speak out, whether by majority decision or in dissent or in public platforms on matters of subsequent democracy that need black therapy and the reasoning that support the best concept of our constitution? Thank you.
Well, I would stand to it. And say that I think all judges, black and white, must refrain from participating in debates in a way which will take away from society's belief in their independence and impartiality. And we must be very careful about that, black judges and white. But there is a different problem, because things are opening up a little and people have very different views. So you'll probably find that someone like me has always talked a great deal more to others and been expressing my views and listening to other people's views and so on, because I think that my view of society is that isolation and independence are different things. The more the people I talk to, the more the views I hear, the more I get a sense of what's happening, the better I understand things. And therefore I would quite easily participate in a debate with people and so on. But that is because the people I participate in the debate with will know that they will not be able to influence me unduly. They'll be able to influence me duly, which is good and proper. There's no problem about that. But they will not be able to influence me unduly. So I think every judge, there are differences of opinion on that now, and judges make their own decisions in these things. I must say I've always taken the view that isolation on the one hand and independence and impartiality on the other are two different things, and that the better you understand human beings, the better the judge you become, and you can only understand human beings better if you interact.
Thank you for that. Yes, I would like to invite more questions here. There's one here, and then you have to go back to the back for those two hands there.
Justice Yacoob, I'd like to ask how you would react to what might at first blush seem like an overzealous charge that the courts or the judiciary has itself been complicit in aiding and abetting the judicialization of politics, or the rush of people to, or political parties or political actors to go to the courts. Because you brought this up a little bit earlier on in the Mazibuko judgment. Justice Davis brought this up as a problem that is beginning to manifest. Now, what do I mean by being complicit or aiding and abetting? I'm thinking of it in terms of maybe two important ideas in our constitutional jurisprudence. You mentioned Section 34 and the question of justiciability, that when a matter is justiciable, the courts must entertain and deal with it. But by virtue of Section 34 saying that, then and being in the Constitution, the question of justiciability itself is justiciable, but there are no clear guidelines at this point as to what might not be justiciable. So that's point number one. Then the second one then speaks to the seemingly all-pervasive principle of legality, which is the fallback of the courts in certain instances where there isn't a clear rule. And then the last thing I want to say is that the example that you cited as not raising an unjusticiable issue, I would argue can raise one. And the example was two people fighting about whether there is a God or there isn't a God. If we locate those two people at a private church school in South Africa, and somebody refusing, as somebody who's enrolled in that school, refusing to partake in the religious instruction or other religious activities in that school, that could then be raised as a right question. So I would like,
Let me go to the last one first.
Yeah.
But that's a different justiciable question. And that is whether someone's right to freedom of religion has been trenched. The court can't decide whether there's a God or whether there's no God. That's what I was making. And if you say that can be decided, I'd like to hear you further on it.
Very happy.
But there was another question which he asked about what is justiciable and what is not. I think that's the other
I'm
aspect.
saying to you that you can ask the question theoretically, but the issues that we had to decide in each of those cases could never be said to be unjusticiable. I dare any of you to write a judgment would say the ANC has a constitution. The majority, some people come to court to say that it's not complying with its constitution. I want a finding that it's not compliant, that it must comply with its own constitution. I'd love somebody to write a judgment to say that's not a justiciable issue. Whether the ANC complies with its constitution is not the business of anybody, and so on, because people, then you might as well say, that, because that gives rise to disorder, then you might as well say, if I say that somebody owes me 100,000 rand, that's not the court business. That's our business, and we must sort it out. It's like saying that if a husband abuses his wife inside the privacy of the home, that's not a justiciable issue. What's that got to do with the rest of the world? It's got to do with the private thing between husband and wife. They must sort it out. So that is really the beginning of a hugely slippery slide to narrow the definition of justiciability because you want to make a particular point. People are entitled to have things done in the way in which people undertake to do them. If I undertake to pay you 100,000 rand, I must pay. If I have a constitution and I say I will do A, B, and C in terms of our constitution, and that's the constitution on the basis of which people join our political party, then the political party must comply with its own constitution. It is fundamental to democracy. You can't have an undemocratic political party in a democratic election. As far as legality is concerned, I really would like to know what's wrong with saying that it's the fundamental notion of our constitution that every government organ must act lawfully. What's wrong with that? I mean, are you really contending for the notion that organs of state should be authorized to act unlawfully in certain circumstances?
I think, do you want to, should I ask Professor Albertyn to come in on this one?
There's no political question doctrine in South Africa.
I think the proposition here.
So the question is,
we
should
have?
there be one?
Right.
And no, the answer at the moment seems to be not yet.
Not yet.
That we are, that in a sense, what we have done in South Africa in many, many areas, including actually in the Equality Act, is we've given huge power to the courts. There's no question. And we might at some point reach a stage where we say that that power has gone too wide, but I don't think that is. And listening to a judge who's sat on the Constitutional Court for 15 years, I don't think we're there yet. I mean, we are adjudicating matters that wouldn't be adjudicated in other parts of Africa, right? On the political party doctrine. Dennis Davis has expressed concern about the no confidence debate that was taken to me when he felt that it shouldn't be taken. So there's one issue of concern. But I think we're at the very, very beginnings of the debate in terms of that.
I think Dennis Davis.
Sorry, I don't think there's anything necessarily in the Constitution that at the moment helps us.
You see, and although Dennis Davis said that there was a concern, I don't raise these political issues, remember this, that the Constitutional Court didn't hear the dispute. What it did was gave the Speaker of Parliament an opportunity to pass a law, pass a rule aimed at dealing with the question. And that was appropriately intervented. If we had told them to go away, there would not have been a rule drafted by the Speaker, voluntarily, not instructed by the court to do so, how to deal with votes of no confidence. The rules were absolutely silent on how to deal with it. The whole thing was absolutely confused. And now we're going to have a law to deal with it. So it was quite positive, I would say.
Okay, so it's a matter of time that we must wait for the right case.
We might just have a situation where through judicial restraint and remedial powers, where things are thrown back to Parliament, that's how it's managed. And, you know, that might be the way we go in this country. We don't have to follow the US, for example.
So can I speak with or without the mic? I think Justice Yacoob, what I then found quite interesting was your proposed constitutional amendment that maybe the court have a constitutional discretion to refuse even justiciable matters, and again it then revolves around the court. And I think in terms of even our doctrine of separation of powers, it raises very, very, very interesting questions. Is that you know, is the doctrine of separation of powers what the court says it is, or is there something else that we can hold on to in quite a definitive sense? Because I think there is a legitimate concern that we may have arising a juristocracy, which ends up being where the jurisprudence ends up being out of sync or out of touch with where society is, and that in itself can erode the legitimacy of the court. And so what I was really asking was, with respect to justiciability, is it not appropriate that there should be some guidelines, or this question as to, you know, what is justiciable be addressed in a clearer fashion in the court?
It would be very difficult to draft something like that, because every which way you draft a definition of justiciability, it would always be open to different constructions. unless you reduce it to a mechanical exercise. So the first thing is, it's very difficult to see how everybody is going to agree on a definition. All the politicians understand about separation of powers is that we don't want the courts, we want the courts to interfere with us as little as possible. And that's the kind of law that the politicians will pass. Nobody is particularly interested in the kind of notions that you are talking about. Nobody even particularly understands what we are talking about. So while I personally think that it may be a good idea, I think it will be a very, very difficult law to draft. It's going to be very complicated. And I disagree completely, by the way, that we are in a juristocracy at the moment. We've been very careful in the way in which we have done things. There may be one or two cases where some people may contend that we've gone too far, but that is within the bounds of differences of opinion. And differences of opinion, there will always be. You will never ever get a situation in any country in the world where everyone agrees with every judgment of
Okay, there was a hand in the back there. Yeah.
Justice Yacoob, I'm asking the question partly because it gives me an opportunity to stand, but partly also because I'm really interested in your answer. It's not a jurisprudential question at all. In fact, it relates to the inner workings of the court. I shan't ask a question about conferences or the dynamic between the judges, the relationships between various judges, etc. The question I want to ask relates to what the category now known as researchers, formerly known as clerks. You made reference to the need for guidelines in selecting judges in South Africa. Now my question to you is twofold. Firstly, how did you personally go about selecting your particular clerks or researchers? And then secondly, what particular role did they play in your chambers? Because my understanding is that each one employed them differently.
Yeah, I took into account affirmative action greatly, though I also took into account the need to appoint white people from time to time. Because I was not so clever myself, I avoided the very clever people. You know, they trouble you too much. So I used to take the ones with 60-70% passes. Most of them would come from disadvantaged universities. Some of them would not come from there, and I would pick those who had potential, who had potential to think, who are warm human beings, because I really think that the kind of human being you are is quite important, and who are honest. I mean, you'd ask a clerk what is their favorite judgment, and they would say their favorite judgment is Pakwanyane. You ask them whether they read it carefully. They say they read it carefully, and then you ask them, then you realize that they didn't even know that all 11 judges wrote a judgment in it. So that sort of clerk, however good he is or she is, however much they may benefit from affirmative action, goes. So whenever a clerk lied to me in an interview, that's gone completely. For the rest, I pick in that way. As far as my clerks are concerned, they do notes for me on cases. They make recommendations to me, and I decide which way they should go. They do notes for me on cases to be heard. We discuss them quite carefully. We discuss carefully the results. Quite often we have a difference of opinion on how the case should be decided. And in the same way as I take my colleagues' opinion seriously, I also take my clerk's opinions reasonably seriously, except that I can't say to my colleagues they're talking nonsense. I can say that to my clerks. And I have an arrangement with my clerks always that we must operate on the basis that I give you no quarter, you give me no quarter. You argue for your position, you stand up for your own position, I stand up for my position, and that's about it. They do a lot of work, the club. They do a lot of research in particular areas. They give me notes on particular areas of particular cases. I ask them to give me summaries of cases. They read them and they give them to me. And then I suppose their trouble comes when, so I draft the judgments and they fill in all the footnotes. It's a lovely thing to have clerks do. They fill in all the footnotes, they put in all the quotations that I want put in, and they also make an input on how the thing should be drafted. And if they make a good suggestion, I would normally accept it. I mean, I've even accepted the suggestion of a clerk to restructure a judgment completely.
Okay. Yeah, there's one hand here, and there's one behind there. Maybe let's take those two one after the other. Yeah.
Thanks. This is to Justice Yacoob and possibly Professor Albertyn as well. Just to build up on Sibanda's argument about legality, I don't think it's so much so a genuine concern about legality, but the fact that Paja is now not being used. There seems to be a subtle avoidance of Paja by litigants, and instead they're using legality, which has, by the way, been acknowledged as an aspect of the rule of law by the Constitutional Court. But don't you think that the proliferation of pathways to judicial review, and in particular legality, is being used instead of legislation which was given effect by a constitutional provision? Thanks.
So I have no problem with that. I think it is absolutely right that everyone involved in government must act lawfully every step of the way. And if governments don't act lawfully, that is unconstitutional. I don't much care how much life I give to people. For me, more people taking on government on the basis that they act unlawfully is preferable to condoning government unlawfulness and allowing them to carry on acting unlawfully. I think it's perfectly right that unlawful action, I'd like someone to demonstrate, instead of asking the question, can someone demonstrate the proposition that unlawful action can be arguably constitutional in our democracy by a government office? Is it ever possible to demonstrate such a proposition?
Well, while I let you think about that question, Professor Albertyn, you wanna okay.
No, thank you. I was most impressed by the question. I don't want to answer it.
Okay, there, hand there. No, yeah, she had it, yeah.
This is for both speakers. I'm taking us back to the JSC discussion, and I'm interested in knowing or probing what exactly would be the effectiveness, in your view, of having guidelines for the JSC as it's currently constituted. I don't think it's a bad idea necessarily, but I'm just questioning, we already have, if I understand it correctly, a requirement that the judiciary be representative. One of the concerns about the non-appointment of women is that it's actually not complying with the constitutional requirements. So we already have some sense of a guideline that's in place, and that's simply being ignored. It's not being taken into account, and we don't have any reasons for that. So what will the effectiveness of guidelines be if the JSC as currently constituted isn't being held accountable? And is that more of a problem in your view on the extent to which the public actually takes an active interest and is willing to push the point of what is influencing the appointment of judges?
Well, I think the JSC must be accountable. I think that the evaluation, it would be guidelines for the evaluation of candidates, and it would be those evaluations which would determine who is appointed. So I would imagine that, and I mean, those evaluations should be made available, should be made public at some level or other. And I would imagine that if a woman and a man were evaluated more or less the same in circumstances where we needed an extra woman on the judiciary, the appointment of the man would just be unjustifiable in terms of the guidelines. Might even be irrational in the circumstances. So they have to be accountable to some extent. It's like social and economic rights. It's not whether they are accountable. It's using our creativity to render the Judicial Services Commission as accountable as they can be in the circumstances to avoid a wholly subjective means for the appointment of judges. At the moment, it's all the subjective view of the people who vote. It has nothing to do with anything else. We'll never have an absolutely wonderful judicial appointment process. Somebody said to me that the judicial appointment process is wonderful only in the view of the judge who was appointed. But we'll never have an absolutely superb appointment process. But my only position is that guidelines make people work as it better, and they've got to conduct the evaluations in a particular way, and the application of the guidelines does give rise to a measure of fairness and a measure of consistency, all of which are important notions in the appointment of judges.
Professor
I
Albertyn?
think we want to come in. I've spoken no.
Okay.
So, on this.
Can I have this there in the front and then we'll go here, and then we'll begin to wrap up. Maybe we'll take one or more, two questions. Okay, go ahead.
Okay. Whilst we're on that topic of appointment of justices in the Constitutional Court and the idea of accountability, then can we not say that it is the composition of the JSC itself that will then create, make sure that we are creating or reproducing, as the professor said, the same judges. It is not the fact that we are already, the construction and the composition of the JSC is made up of people that are common-minded, people that will likely go for the same values, the same ideas and things like that. Should we not then make it more restrictive? Should we not restrain the composition of the JSC? Should we not make it more harder to become part of the JSC itself? Can we not then start at the root of the JSC and then see if that does not influence the way that judicial officials are elected and appointed?
I just wanted to add that it is not only the appointment process, the people on the Judicial Services Commission in a sense, which gives rise to the problem. I think you've got to understand that the majority of lawyers are conservative. The majority of lawyers believe in positive law. The majority of lawyers, because of their training and what they've learned, all these corporate lawyers everywhere and so on, see humanity as not particularly important. And I think that then lawyers become judges. And it is inevitable. There was a time when we had a lot of humanist people appointed as judges. It was almost a transitionary period. But once it's wrong to believe that black people will be more humanist judges than white won't. The law is a very conservative art. You look at, and even law lectures, a large number of them are highly conservative in relation to their value systems and so on and so on. And that's why you will go back to a slightly more conservative judiciary sometime before it gets better. It's almost inevitable.
I suppose I as a citizen want to know that my judges have integrity, are honest. I want to know what their judicial philosophy is. I want to know that they have empathy with people who are different. There are a whole lot of things I want to know about them, and I can only learn about them through the appointment process, and I want them to be judged in that way. So that's, if you have those kinds of criteria and you have open interviews, in that way you can begin to build accountability of the JSC. And in that way, maybe the JSC begins to build some of its own expertise. I mean, I'm not not sure how many people in the JSC could have a discussion about judicial philosophy with a candidate judge. But to me, if you begin to try and force it that way, I'm not sure we're going to be able to change the institution realistically. So let's work with getting criteria in place and trying to get accountability and legitimacy and see where that takes us. That seems to be some kind of wedge into getting a better selection process going.
Okay, we are almost out of time, so I'm going to take the last few questions. I think let's start from there. We'll come here and then we'll go two hands.
It's a very short question. Why do you think that Gauntlet was not shortlisted in the last round? I just want to preface it by now, I'm not saying if I ask him this question, I'm not going to bat for him, but I think it's an important
I don't know why it was
issue.
not shortlisted before. But my sense is, I mean, when you were not shortlisted again, I wondered what the position was. When I read the newspaper, it was fairly clear. I mean, they didn't like the fact, the things he said about them. And that was the reason. And I think that there is an argument that he didn't show enough discipline that one is expected a judge to show. And therefore, by his lack of discipline, demonstrated one further reason why he shouldn't be appointed. That's my own personal
Let's have and here and then we'll move to the side.
My question was also on Gauntlet. Do you think if these guidelines you're suggesting were in place and there was more objective criteria to choose judges, that you wouldn't have been passed up twice for the concourse and 3 times for the bench? And in terms of the guidelines, obviously the interview process is transparent. Do you think the actual decision making, why this one is chosen and that one not?
I don't know. My problem is that I'm not in a position to evaluate the other candidates. So unless you look at the others and unless you look at pros and cons and so on, some of these decisions are very, very difficult. And really you can't say that somebody absolutely qualifies to be appointed come what may. It's always a question of the comparison of candidates and what values you apply. So I must say I don't know. I don't know. The reason why one doesn't know, and one would know if there were guidelines and if they had to tell us something. But if what happens is that all people just vote, then one never knows.
Okay, this good. Yeah.
My question goes to both speakers. I just wanted to find out, particularly taking you back to when we started talking about certainty and certainty of the law. I wanted to know, regarding enforcing the rights of the Constitution, why does it seem like that there's always a difficulty in terms of enforcing those rights, especially in terms of social economic rights, specifically to the case of Grootboom, where she actually did have the opportunity for her matter to be heard by the Constitutional Court, but then she only really got the house after she passed away, and she stayed many years without it, and she never lived long enough for her to see the realization of her rights being enforced. So it's kind of something that left me in limbo because it's a topic that we had at varsity, and even though I never really got a conclusion on that, and I just thought I'd have the opportunity to.
The conclusion is very easy. You must just read the case very carefully, and the conclusion will appear. The problem is that in Grootboom, we did not decide Grootboom's case. Grootboom was asking for temporary shelter, and her case was settled between the government and Grootboom, so that we were not deciding and expressly did not decide what Mrs. Grootboom was entitled to. That was settled. The only order we made was to say that the government must make its program more flexible. So there was no specific order about Grootboom. There was no need for a specific order on Grootboom, because the case between Mrs. Grootboom and a group of people and the government was settled on the morning of the case.
Okay, we're going to take the last question right in the back.
A question for the professor. Nearly 19 years now hindsight. If you had the opportunity, what single change would you make to the Constitution? Then, just why, with 19 years and 2 minutes of hindsight, change would you make to the Constitution?
Mr. Albertyn?
Single change, I know, sorry. I would not separate subsection 1 and 2 in sections 26 and 27 in such a way as I would try and rephrase socioeconomic rights in such a way that the courts were forced to give some kind of substantive content to the right before deciding that it was progressively realizable.
Okay, fair enough.
I may have tried to do the same thing, but I would have failed. But mine is a rather selfish one in a way. I would not have limited the Constitutional Court judges' terms to 15 years. although it's beneficial to be now, it's wonderful not to be there and to be paid a full judge's salary. But the problem is that in a country like this, can you afford to pay somebody forever for doing nothing? And can we? And the deliberate political intention there was to shuffle the pack often enough so that the court gets weaker, and by definition the executive gets stronger. That's obviously the political motivation. And I would have made the Constitutional Court the highest court in the land from the beginning. And I think it would be very nice to do that now. And that's the bottom.
Well, thank you for that. I mean, I agree with you, Justice Yacoob. I am in favor of appointing judges to the court for life. So
not for life, they must have a 75-year retirement age or something. Because when you get to 85, 90 and you stick around there, it's no good. But I mean, these days, it's so big when they're 70, 75. Yeah.
No, thank you very much. I think we will come to the end of this part, and I'm going to hand over back to Mr. Sibanda to just say the final word and direct where we need to go next.
I guess my last act is to say thank you. To say thank you very much to the audience who have participated and made this the first in conversation with the Judiciary Speaker Series event a success and very, very enjoyable. I then to say thank you to our speakers for a very considered, thought-provoking and engaging conversation, which was at times robust. Now to Justice Yacoob, our judge in the spotlight and not in the hot seat. We say thank you very much for being personable, very generous. You were funny, you made us laugh quite a lot of times. I'm sure that's the most laughter this auditorium has heard in a long time. But in particular, we really thank you for being honest and frank. You didn't vacillate, and you really put your thoughts out there to some very difficult and probing questions. So we really appreciate that. And the only thing we can ask of you, yes, we continue to ask, is that you put the word out there to other members of the judiciary, retired and sitting, that we are not inviting people here to grill them. If at any point it seems to stray towards a grilling, it's because we are passionate. And we love the law, and we love good, honest, and engaging conversation. And we say thank you very much. If we can have a round of applause for our panel. Then the last thing is to invite everybody over into the room to my left for some cocktails and some refreshments. Thank you.